All right. Today is the date set for a status review. Mr. Blumberg, do we have a resolution of this matter?
We do, Your Honor. Mr. Richardson is going to be entering a no contest plea to count 3 domestic violence. In consideration of that, counts 1, 2, and 4 would be dismissed, along with a forfeiture of the firearm that was somewhat involved in this incident. And the reason for a no contest plea is that he's embroiled in a custody matter in civil litigation. And as a result, I think a plea would be inappropriate at this time.
Ms. Brucker?
That's correct, Your Honor.
All right, Mr. Richardson, you've heard what the attorneys have said. Is that what you want to do?
Yes, Your Honor.
All right, I understand the agreement to be that you're going to plead guilty to the count 3 misdemeanor called domestic violence. That count 1, the home invasion felony, would be dismissed. Count 2, the interfering with electronic communications felony, would be dismissed. And count 4, the wet firearms charge, would be dismissed. But you are agreeing to forfeit the firearm. Is that your understanding of the agreement?
Yes, Your Honor.
All right. If you want to take advantage of that agreement, you would be giving up your right to have a trial and all of the things that would go along with a trial. Do you understand that?
Yes, Your Honor.
Let me detail those things for you. If you were to have a trial, you'd have the right to have a trial before a judge or a jury. You'd have the right to be represented by your attorney at that trial. You could see, hear, and question all the witnesses at trial. You could get a subpoena from the court to require your witnesses to appear and testify. At a trial, you could testify, or you could choose to remain silent. And if you remain silent, that could not be used against you. At a trial, you'd be presumed innocent until proven guilty beyond a reasonable doubt, and that burden of proof would remain with the prosecutor at all times. Finally, at a trial, you'd have the right to automatically appeal, but if you enter a plea, you'd be limited to asking the court for permission to appeal, and that might not be granted. Do you understand all of those rights?
Yes, Your Honor.
Do you have any questions about any of those rights?
No, I don't.
Knowing all of that, do you still wish to enter your plea today?
Yes.
All right. If you raise your right hand so I can swear you in. You swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
I do. Again, Your Honor, it is no contest plea. I'm sorry.
Yep. Let me get through this, the first preliminary ones, and then we'll go to that. Thank you, but thank you for the reminder, Mr. Blumberg.
Sure.
Mr. Richardson, has anybody promised you anything other than this plea agreement to get you to plead today?
No, Your Honor.
Has anybody threatened you in any way to get you to plead today?
No, Your Honor.
You doing this of your own free choice and free will?
Yes, I am.
The agreement reached at the opening of this hearing immediately reveals that this case is no longer about proving what happened. It is about controlling the legal damage that still reaches beyond the criminal courtroom.
All right, Mr. Blumberg, what do you propose that we use for the no contest plea?
Judge, do you have a copy of the police report in the court file?
I have a short copy of the affidavit of probable cause, which has got about a paragraph length of material to it. You want me to use that?
Well, sure. I was hoping you had something other than that, but we would not object to that.
Well,
Your Honor, if the court would like more information aside from what's in the affidavit, and I'll let the court take a look at the affidavit, I can forward the supplemental report onto Mr. Horrigan.
yeah, let me look at this first. I've got nothing that resembles a police report, and I typically don't, but let me look at this first. I think I've got the gist of things that occurred, Mr. Blumberg. Is there something more that you'd like for plea taking purposes, or do you want to have me review something in more detail?
No, Judge, I think the affidavit probably would be sufficient. if there's questions, certainly at the time of sentencing, we can explain to the court our view of the incident.
All right. I do believe that the affidavit gives sufficient facts for a plea to domestic violence. It does indicate that Mr. Richardson was found at a residence in Michoud, which is within Otsego County, on March 11th, 2026, and that the police investigated, and there was a firearm located within the residence, and there was allegations that he had assaulted his wife at an Airbnb at that location, and he was arrested and taken into custody on domestic assault as a result of that. From that, I can conclude that the elements of domestic violence, assault on a person with whom you have a domestic relationship, a spouse, occurred in Otsego County on March 11th, and therefore I will accept the plea. It appears to me to have been given knowingly, intelligently, and voluntarily based on his answers to my questions, so I will accept the plea. Let me get a sentencing date so we can have, I'm assuming that you want to do that out in the future, Mr. Blumberg and Ms. Brucker?
Oh, actually, Judge, we had submitted to the court an extensive set of documents relating to Mr. Richardson's counseling and mental health issues that brings him before the court today. He was certainly hopeful that you would be able to sentence him today, but if the court's not prepared to do that, certainly we understand.
We have submitted victim impact statements. I had anticipated, based on my conversations with Mr. Blumberg, that we go forward today. And in addition, one of the victims is also here today.
All right. And I have not yet had a chance to review the submissions by counsel on both sides. So give me a minute to do that, and then we can take up the issue of sentencing. Psychiatric and mental health treatment, and I've reviewed the victim impact statement from Nathan Rozeski and from Elizabeth Richardson from the prosecutor's office. Is there a victim that wishes to make a statement to me in court?
Your Honor, I see Mr. Rozeski is here. I'd ask him whether he also wanted to add anything verbally. We provided notice to Ms. Richardson of the hearing, but I don't see her here, so obviously she would not be speaking. He's raising his hand. I think he's trying to figure out how to unmute, possibly.
Yep, if you would unmute yourself, Mr. Rozeski, I'd be happy to hear from you at this time.
Thank you, Your Honor. I do have tons of things that I would like to say. However, I will keep it short. As you guys entered a plea, I would like to say to you, Mr. Richardson, that you are extremely fortunate that one of the males in this extremely dangerous and unnecessary situation possessed the mental stability and maturity to fuse the situation at the best of their ability.
The judge recognizes that balance and spends significant time making sure every constitutional right is knowingly surrendered. That careful process matters because any mistake could threaten the entire agreement later.
I truly hope that you get the mental help that you greatly need for your son's sake and for yours. I ask the prosecution to please place a no contact or PPO against Mr. Richardson for all of my children and myself for the indefinite. I am currently shaking because I don't believe that you guys understand the severity of what happened that day. This was very traumatic for multiple people, including a 15-year-old male, a 10-year-old or 9-year-old male, and the 2 adults. You had no right to enter that home at all. And I will leave it at that.
Thank you, sir. I appreciate the time and the information for that. All right. Ms. Brucker, any other comments that you wish to make?
I just add a few things. I know the court read the affidavit and has some knowledge of the facts, but Mr. Richardson on that day tracked his soon-to-be ex-wife using some kind of tracker to the home that she was renting. Prior to that day, I don't believe he knew where the residence was. He observed another vehicle in the driveway, so he went to the front door to confront her about that. After he spoke to her, he essentially pushed his way into the house without any permission. He was a CPL holder, so he had his pistol with him, although from my reading of the report, it was in his pocket or something like that. But he did have that with him. Miss Richardson was aware that she called out to the people who were in the home, including Mr. Rozewski, his child, and Mr. Richardson's child, that he had come in the house with a gun. He did not find, Mr. Rozewski. That was who he was trying to locate in the home. He did encounter his son, and it's my understanding, and I think he wrote this in his impact statement, that he spoke to his son rather aggressively. He left the house after that. Miss Richardson and their son got into the vehicle with him. She was very concerned that he was going to harm himself or someone else at that point, and they went back to his home. Police were called, and then he was placed under arrest for domestic violence and a number of other things. I think the court can tell from the impact statements and from Mr. Rozewski's statements how this has impacted him and his son. It obviously was very traumatic for everyone, including Mr. Richardson's soon-to-be ex-wife and their child as well. So what I'm asking the court to do, and pursuant to the plea, to forfeit the firearm, and for the clerk's benefit, or for the court's benefit, I'm sorry, it is a Ruger pistol model SR40. We would oppose a deferral on this matter, and that was not anything that was part of the plea offer due to the safety of himself and the community. We do want to limit his access to firearms because we're concerned about what he could do. And that's really one of the things from that evening is it's not just what he did, but it's about, for everyone else who was there, what he could have done if he had found the people who were in the home that he was looking for, with what his poor state of mind was at that time. I would ask for the court to place him on a very long term of probation to ensure that he follows the no contact orders and that he continues with his mental health treatment. I would also ask for the court to impose some upfront jail on this matter.
Thank you, Ms. Brucker. Mr. Blumberg, allocution.
Thank you, Judge. And I want to be very thoughtful about my remarks because I'm very familiar with the facts of this case. And while I don't doubt that Mr. Rozewski felt traumatized, the fact of the matter is my client, who is a honorably discharged military veteran who suffers from PTSD, discovered that his wife was having an affair with Mr. Rozewski. And that's not any justification for his conduct. But given his mental health, it set him off, and he went there to confront his wife. It's not a soon-to-be ex-wife. They're in the very early stages of a divorce proceeding. He was there also to see his son, who has been denied access by my client's wife. I think the veteran administration records reflect the fact.
The judge is not interested in assumptions or convenience. He wants enough evidence on the record to justify accepting the plea while keeping the process legally solid. Before punishment is even discussed, the courtroom is focused on protecting the integrity of the case itself, making procedure just as important as the outcome.
That he suffers from a significant mental health issue. He has attempted suicide in the past, and in fact, the episode that brought him before the court likely would have resulted in some type of a tragedy of his own taking. It's interesting that his wife forced herself into his vehicle to take him home because she was also concerned about his mental health. I don't believe any upfront jail time is appropriate in this matter. He is incredibly regretful. He has been hospitalized as a result of this incident. He continues to be taking his medication and continuing his counseling. I think a period of probation with all sorts of restraints in terms of things that he can do and can't do would be appropriate in lieu of incarceration. And if they're considering such period of incarceration, we would ask that it be held in abeyance pending his adjustment to counseling. My client is a good guy. He has never been in trouble before, and this was an unfortunate set of circumstances set off by the infidelity of his wife. And we would ask the court to at least take that into consideration. Thank you.
Mr. Richardson, you also have the right to address the court before I decide what to do. Is there anything that you would like to say?
No, Your Honor.
This is your opportunity, Mr. Richardson.
Do you feel like you can say something? Judge, he's a little overwhelmed by this whole process and doesn't feel comfortable addressing the court.
All right, thank you. All right, Mr. Richardson, I'm going to do the easy things first, and then I'll get some contemplation to the more difficult things. Given the circumstances of this case, it's clear to me that a long period of probation is necessary. The maximum I can impose under the district court rules is 2 years, so I'm going to do that. There's an oversight fee of $720 for that. There's a mandatory $75 crime victim fee, a mandatory justice assessment of $50. Court costs of $200, a fine of $100, and a local charge of $15. It's a total of $1,160. You pay that over the course of your probation. You may perform some community service work in lieu of fines and costs at the discretion of the probation department. I'm going to require you to attend and successfully complete the men's batterers program. And complete all mental health treatment as recommended by your VA doctors.
The hearing shifts once the focus moves away from legal procedure and toward human impact. That transition changes the emotional balance of the courtroom because the discussion is no longer centered on paperwork or plea negotiations.
You must sign a release to probation so they can monitor your progress. While you're on probation, there's no consumption or possession of alcohol or drugs. No entrance into business where alcohol is served by the glass. There is alcohol and drug testing. You may not associate with victim in this case, or victims. Nathan Rashevsky. And his family members. And you may not have contact with Emily Richardson.
It's Elizabeth, Your Honor.
I'm sorry, thank you. There's to be no assaultive, abusive, intimidating, or threatening behavior while you're on probation. You may not possess a firearm. And you will forfeit the Ruger pistol model SR40. Mr. Blumberg, what was your client's duties in as an active member of the military?
He had active service and was in the midst of all of the horrific damage that was done in the Middle East, both in Iraq,
Just after this.
and I'm sorry, in Afghanistan. He saw things and participated in the most horrific type of combat that one can reasonably imagine. And it has had a damaging, profound effect on the remainder of his life. He struggles with his mental health, and he has actively involved himself in all the counseling that's made available to him through the Veterans Administration. The events of the day that brings him before the court is regrettable, and he will live with that for the rest of his life. He has not been able to see his own son as a result of that incident. He struggles with the anxiety. He has attempted suicide in the past, and he's doing the best he can. And to simply throw him in the county jail is not going to be of any benefit to him, and it won't benefit those that he's now prohibited from having contact with. I would ask the court to seriously consider, as I had suggested before, if the court feels inclined to impose jail time, to at least hold it in abeyance and let him prove to the court that he can maintain his treatment and be a productive member. He's gainfully employed, goes to work every day. He does the best that he can given the circumstances that he has. I would just ask the court to give him the opportunity to show the court that he's worthy of that consideration.
Thank you, Mr. Blumberg. My concern is that he's inflicted his mental horrors on someone else. When you show up at somebody's house looking for someone that you think has done you wrong, that is the exact mental state that this court needs to prevent from happening. And his actions.
The victim's statement is not built around punishment alone. It emphasizes lasting psychological damage, especially the effect on children who became unwilling participants in an adult conflict. That changes how the court evaluates risk, because emotional harm is harder to measure than physical evidence.
At that household has inflicted some of his horrors on the people within the household, specifically the minors. I understand the circumstances under which he went there, but you don't get to bring a gun to the household of someone that you suspect is having an affair with your wife, right, wrong, or otherwise. You don't get to break into that house, and you certainly don't get to corner a kid and harangue him about where the dad is. I don't care what you saw in Afghanistan. And I can't imagine what he saw, but it's still, that's just common sense. And he knows better than to bring a gun to those set of circumstances, because he served in the military with weapons all of the time. And that was beat into him at boot camp. You're there, your job in the military is to protect and serve. You don't get to intimidate and abuse. The reason that I haven't just said go to jail, go directly to jail, do not pass go, is because of his service. Otherwise, he'd be looking at 93 days. in reality, there is no good way to resolve this matter. Mr. Razuski is correct. He needs to be protected. His family needs to be protected. On the other hand, Mr. Richardson has put himself in harm's way for his country, and he is living with the consequences of that. And I'm giving him the benefit of the doubt by saying I think he is trying his best, but he's got to do better because he can't transfer that horror to anybody else. And that's what he did in this case. He poured out his wrath on those kids, put them in harm's way. They now have to live with that. Mr. Blumberg, where does your client work at?
At Mega Power Sports here in Gaylord.
The 40-hour work week?
I believe that it is.
When was the last time he was inpatient for treatment?
He was hospitalized not too very long ago, right after this incident, so a couple months ago, I believe.
I read in the veterans information that was in April. Was that the last time he was in?
Yes.
How long was he in for?
You remember how long you were in?
5 days.
Yeah. I believe it was 4 or 5 days.
Here's what I'd like to do, Mr. Blumberg. I would like to have him get the treatment that you're asking for him to get. I don't know that it's going to be available, so I'm going to give you some time to do what I'm asking, and then I'm going to impose an alternative if that doesn't work. I would like him to go to an inpatient treatment program, and I don't know that there even is one, but I'd like him to go for an inpatient treatment program for about 60 days to stabilize his mental health.
The prosecution deliberately expands the discussion beyond the charge that remains after the plea agreement. Instead of focusing only on domestic violence, the argument paints a broader picture of calculated decision-making leading up to the confrontation.
And I would give him credit for the 60 days that he would be in that program as if he were in jail, because he would be off the streets and he would be not free to leave the inpatient treatment program. That I think does the best of both worlds. It satisfies the victim's need for him to be punished, that is, put away, not available out on the streets and in the public, for a sufficient amount of time that I think they can say justice has been served. But it also gives your client the opportunity to address his mental health needs. I don't know that such a program exists. I don't have access to it today. So I'm going to give you, Mr. Blumberg, an opportunity to find that for me. And I'm going to reschedule the sentencing for approximately 2 weeks from today, at which time you can inform me whether or not you found such a program, and I'll order him to go to it. Or if not, I'm going to impose 60 days in jail. What do we have for a date for 2 weeks from now?
2 weeks from today, we can do the 25th in the afternoon.
June 25th at 1:30 would be the next court date.
If you could just give me a moment, I want to make sure that.
Yep. I want to see if you don't have, make sure you don't have a conflict.
Thanks. I'm sorry, that's the 25th?
Yep, June 25th at 1:30 via Zoom.
Okay. No, I'm available. Thank you.
All right. So we will reappear at that time, and I will continue the sentencing. I'm intending to impose all of the things that I imposed today. The only thing I have left to do is determine whether or not he goes to jail or he goes to an inpatient treatment program. So I'll leave that to your creative devices, Mr. Blumberg, and I'll see you on the 25th, and you can let me know what you found out.
I understand. Thank you.
Thank you very much. That's all for today.
Thank you.
You just have a seat out there so we can talk. Okay, I got this other day. Judge, I have one other matter. Would you be inclined to take that, or should I just come back?
I've got the jail waiting on 3 arraignments, so I apologize for that, Mr. Blumberg, but I was supposed to take them at 1:30, and here we are at 2:30, so I apologize. I'm not able to, otherwise I would take you next.
No, I appreciate it. I apologize for taking up so much of the court's time.
No, that's not your fault at all, so I appreciate that. All right, who do we have at the jail, please? Unfortunately, the jail's on mute.
The prosecutor is asking the judge to think about what could have happened, not just what ultimately occurred. At the same time, the defense counters with a completely different framework. Instead of denying responsibility, it attempts to explain the emotional collapse behind the conduct. PTSD, military service, broken family relationships, and documented mental health struggles are presented as factors that deserve treatment instead of harsher punishment. The courtroom is now weighing public safety against personal rehabilitation. The final portion of the hearing exposes the judge's true priority. Every probation condition reflects a belief that future prevention matters more than simply responding to past misconduct. Mental health treatment, firearm restrictions, batterer intervention, substance limits, monitoring, and strict no-contact provisions all point toward controlling future risk instead of relying only on punishment. When the defense makes one last appeal based on military service and severe psychological trauma, the judge openly acknowledges those sacrifices without allowing them to erase responsibility. That distinction defines the entire sentencing philosophy. Service explains hardship, but it cannot justify transferring that trauma onto innocent people, especially children. Rather than choosing immediate incarceration or unconditional leniency, the judge searches for a solution that addresses both accountability and rehabilitation. His proposal for inpatient treatment instead of jail is neither mercy nor avoidance. It is a practical attempt to reduce future danger while recognizing documented mental illness. By continuing sentencing, the court places responsibility back on the defense to prove meaningful treatment is available. The unresolved ending keeps pressure on everyone involved because the final outcome now depends on action instead of promises.